into the Facebook, so we can actually have a good sense of who you are. Can we just use a moment to do that? All right, great. We have a few answers: business owner, employee.
Okay, looks like mostly employees. Okay, business owner.
Okay, great.
Okay.
All right. Thank you for taking the time out and joining us here today in our Room to Infinity series, which is an initiative run by Enterprise Asia Center for Entrepreneurship, which is also a joint collaboration between Enterprise Asia and Help University. Just let me briefly give a brief introduction to all of the partners here. Enterprise Asia is a leading non-governmental organization in pursuit of creating an Asia that is rich in entrepreneurship as an engine towards sustainable and progressive economic and social development. And the Enterprise Asia Center for Entrepreneurship, the objective is to accelerate the growth of entrepreneurs in Malaysia and across Asia through evidence-based industry best practices, curating transferable framework for shared values practices, and aggregation of innovation and innovative practices. And in the Room Infinity here today is actually a series of entrepreneurial sharing session, which is an initiative by the center to educate businesses and concurrently empower youth on thought-provoking topics and promoting entrepreneurship in the process. And our partner Help University, a leading institution of higher learning in Malaysia, and is the first private university in Southeast Asia to achieve 5 stars in 8 categories in the 2020 QS Stars University ratings. So without further ado, let me briefly introduce our speaker of the day, Chen Yu Szen. He is the partner of Messrs. Anton and Chen. Yu Szen holds a Bachelor of Law degree with honors from the University of West of England of Bristol. He was called to the English bar as a member of the Honourable Society of Middle Temple in 2013 and currently heads the Employment, Family and Corporate Division of the firm. He handles disputes relating to employment and industrial matters and has appeared as lead and junior counsel at all levels of the Malaysian court system. At the same time, providing corporate legal advice in context of employment to small medium enterprises, as well as handling various employment policies for companies in Malaysia. So today's live talk, Yu Szen will be sharing with us about the legal options which the employers can take during the COVID-19 period, such as implementing reduction of salary or working hours, retrenchment, temporary layoffs, and various separation schemes that employers can utilize. He will also brief us on key considerations before implementing all this, as well as suggesting the best practices that employers can take. So before we jump to the presentation, I'd like to address this to the audience that we'll be running a live Q&A at the end of the presentation. As you're watching this from the FB live streaming, if you have any questions at all, just pop them in there. All right, and right now let's hear from Yu Szen.
Hello, everyone. Yes, I'm Yu Szen, and I just like to thank everybody for tuning in. I'm just looking at the live comments, and I'm seeing a majority of employees. I would also give some advice in relation to employees, but these slides are in particular from the employee's perspective. Okay, so I'll start. Okay, in MCO, employers are faced with many challenges, and one of them is cost cutting. What do I do as an employee? What can I do? And there are a few options. course, and I will discuss these few options. And these options are, number one, you can do a reduction of salary, you can do a temporary layoff, you can do what's called a voluntary separation scheme, a mutual separation scheme, as well as retrenchment. Now, of course, these options are suggested options. There are many ways in which an employer can use those options, and it must be done carefully. Not only must it be done carefully, it must be done to minimize risk, so that your employees would not file a claim either in industrial court or labor court. Yeah, so I'll go through these options. Now, before considering these options, there must be a few factors to consider, right? And first of which is a status of an employee. Now, the first thing before you even talk about a reduction of a salary, before you even talk about a voluntary separation scheme, you have to consider whether or not the employee is covered under the Employment Act. And that's the first thing which I'll cover later. For employees who are not covered under the Employment Act, you would have to look at terms of contract, right? Third, also the number of workers. So when you're looking at either retrenching or you're looking at downsizing your company, you have to look at number of workers and also the financial position of the company. So if, for example, if your company is doing really well and you try to retrench your company, it's going to be not considered a bona fide or genuine, right? So that's a very important prerequisite in terms of what options you want to take. I will also be discussing the consideration by some of these FAQs, some of these guidelines or directives, so to speak, by the Ministry of Human Resources Malaysia. They have been issuing that. And also I'll be considering, and also for employers, you have to consider the wage subsidy. Perhaps if you qualify, then you may consider that. Also, and finally, the consequences of termination. So I'll be discussing, in the event that the employee chooses to bring you to court, what you would do, what are the consequences of it. So there are two things, unfair dismissal and constructive dismissal. Okay, so going back to the status of employee, how do I determine if an employee is covered under the Employment Act? Now, following the Act, first schedule of Employment Act, you would look at the requirement of whether or not they are considered employees of private sector. Usually, most of the employees would be covered under this. Public employees, government servants wouldn't be considered protected under the Employment Act. Secondly, the wage ceiling must not be more than 2,000. So for all employees, generally, you would be covered under the Employment Act if your salary is not more than 2,000, so below 2,000. Okay. Secondly, there are also categories of protected employees who, regardless of the wage ceiling of 2,000 ringgit, are considered to be employees who are covered under the Employment Act, and these include manual laborers, drivers, vehicle mechanics. So these employees in these divisions like manual laborers and drivers, regardless of whether they could be earning 3,000, they could be earning 4,000, they would definitely be covered under the Employment Act. Now, why is this important? Why is the consideration of employment important? Because the Employment Act is basically, if I'll bring an analogy, it's like your employment contract is under the law. So your terms include terms like a notice of termination, how many hours of work, your annual leave, all that is all bundled up nicely in the Employment Act. So employers, you must consider that before you proceed to think about what option. Independent workers and casual workers are not employees. So what are independent workers? Independent workers are people who, for example, they do a contract for service, meaning that they have a particular fixed term, and they are not bound by the term. They are not bound in the sense that they are not permanent employees of the company, right? And they're not classified, so they're independent contractors. These are people are not covered under the Employment Act. And also foreigners, yes, they are protected under the Employment Act, provided they satisfy the requirements under the Employment Act, which is less than 2,000. So if they're less than 2,000, you're a foreigner, yes, you are considered protected under the Employment Act. Okay. Now, I want to address some of these. One of the considerations of before you consider an option of taking reduction of salary and whatnot. There has been FAQs issued by the Ministry of Human Resource, and one of them, chief of which I see in Human Resource, is that the guidelines is that employers must pay. The word is wajib untuk membayar. They have to pay the employees during this MCO. Now, while I understand that these guidelines are just are issued by the Ministry of Human Resources, it is not law. So when it is not law, it is not legally binding. Okay, so employees do need to take cognizance of that. So whether or not you have to pay, during this MCO, it's entirely up to the principles of law, and as well as some of these case laws, or even in fact, if there's an act of parliament to show that there is law, then yes, we can use that law, right? The other, for example, the MCO has a law, and that's the prevention. The law is gazetted in the law is gazetted, and these laws are applicable to everybody, right? And those the MCO laws are an act of parliament which carries consequences. So if you breach a guideline, if you do not follow the guideline, it would be the consequences wouldn't be as severe as for example, a breach of an MCO. So of course, one of the few things that the MCO the MCO law has been imposed is that we cannot go out. These things have a force in law, right? So employers must take into account this factor, right? Okay, there's also the wage subsidy by the government. Now, these wage subsidies are a consideration, because if you want to implement, for example, a wage subsidy, a reduction of salary, you want to reduce your salary from, for example, the employee is earning 3,500, right? And you want to reduce their salary from 3,500 to 3,000, let's say, and a wage subsidy can be a consideration for an employer to utilize, so that, for example, if you're a company with 75 workers or less, you're entitled to a subsidy of 1,200. So every employee gets 1,200. So indeed, in the situation that I've given, 3,500 ringgit, you want to reduce to 3,000. So you would have 1,000 ringgit, 1,200 ringgit as wage subsidy, and the remaining balance would then be paid by you. So this is a very good government initiative by the government to help employers. So some of you employers out there, I think you should really consider this package, okay? But of course, these are subjected to a few requirements. For employees, the wages must be less than 4,000 ringgit, right? And your employer and employee must have been contributing to Pekeso. So if you're an employee and you haven't been contributing to Pekeso, you are not entitled to this wage subsidy, and it is only applicable for employees who are wages 4,000 and below. Okay, you must. Also, I want to highlight one of the requirements by Pekeso is that they must be able to demonstrate a revenue of at least 50%, drop in revenue of 50% from January 2020 compared to the following months. This is not applicable for employees who have 75 workers or less. So I would say this is a pretty well thought out package, and one of these, if you're an employer, please do consider this. Yeah. Okay. Now to understand also what are the consequences of when I talk about risk, I talk about what happens when an employee files a claim at the industrial court. Now, there are generally two types of dismissal, and one of it is unfair dismissal, an express one, or an implied unfair dismissal, which would then be termed as a constructive dismissal. What's the difference? And an unfair dismissal is in a situation where, for example, you retrench your worker, you retrench your employee, you say that, okay, I'm going to give you a 1 month's notice, okay, and I will give you a severance package of possibly 10 days. And the employee will say, okay, thank you very much, this is your termination letter, and I'll bring to court, I will then claim unfair dismissal. For constructive dismissal, it's slightly different. It's an implied dismissal. For example, if you're an employee, your employer asks you, your boss asks you to reduce. They said, okay, John, your salary is 3,000. I would want to reduce it to 2,500. Let's say you feel that is unfair. What you can do is you then resign, and then you then claim a constructive dismissal. So this is a form of implied dismissal. Okay, now as to Section 20 of Industrial Relations Act, an employee can claim unfair dismissal via Section 20 of the Industrial Relations Act. So this is the provision in law that an employee can use to claim unfair dismissal. And to paraphrase this section, it says any workman, any workman who feels that he's been unfairly dismissed without just cause or excuse by his employer may lodge a representation to the Director General of Industrial Relations within 60 days from his termination, right? And by lodging this representation, the employee is seeking for reinstatement to his former employment with the employer. Now, a lot of my clients come to me. They said, "Zen, can I go to court and claim compensation?" It doesn't work like that. You are claiming for reinstatement. You are claiming for pemulihan kerja. So, as an employee, you would have to once you have been terminated, okay, take the letter. From 60 days, you have to take that letter. You have to go to the industrial court, and then you can claim. You have to claim reinstatement, right? And okay, so then some people ask me, then why do some of my friends get terminated and they do get some compensation? Now the court, okay, what happens is when you file an unfair dismissal claim, what happens is that because you're claiming for reinstatement pemulihan kerja, and if your case is dragged out for say 1 year, right, 12 months, the court would still consider that you are claiming for your job back. So take an example. John, he has a salary of 10,000 ringgit, right? And he has been dismissed on the 1st of April. Yeah, 1st of April. Then he lodges the complaint 30 days from 1st of April. And what he would do is then he would go to court and he will go through all the process like reconciliation and whatnot. And then he will finally go to the hearing. Yeah. And after the hearing, after a year of hearing, or let's say 12 months, at the end, for the purpose of calculation, he would get back wages in the event he's deemed to be unfairly dismissed by an industrial court. So, for example, the court is saying, okay, because you have gone through this hearing and you are unfairly dismissed, I'm claiming for wages which you are entitled for the past 12 months. So 12 months times 10, that would be 120,000, or you're looking at 120,000 of back wages. And also the court might award compensation in lieu of reinstatement. What that means? That means that the court is saying, okay, it is not feasible now for you to be reinstated, okay, and then they would then calculate the compensation based on 1 month, 1 year. Okay, so for example, the example I gave just now, John, he's been working for the company for 2 years, for example, he's working for a company. So after 12 months of hearing, all right, he would be entitled to 120,000 of back wages, and if the court deems his reinstatement to not be feasible, then what they would do is order for compensation, and compensation would be calculated 1 month for every year of service. So that would mean 2 years. That would mean 20,000. So total compensation would be 140,000. So, and the reason why I'm highlighting all these consequences, because the employer must have in the back of your mind the risk that your employee, that when you are retrenching your employee, whether you're imposing a policy, whether you're imposing a reduction of salary, you must take into account the consequences and the risks surrounding what you are doing. So you must tread carefully. That's what I'm basically saying. You have to tread carefully in terms of your options. Okay. Okay, now I will just go to, okay, I've already explained what unfair and constructive dismissal means. I want to go to the first option. Okay, first option. Now, there's been a lot of lawyers or HR or even the government would say that for you to reduce your salary, you have to get consent. That is generally true. Yes, you have to get a consent, right? But for protected employees, you cannot reduce the salary unless there are preconditions. Okay, preconditions under the Employment Act. So you cannot reduce unless there is consent, right? That is the general rule. Okay, but I would then discuss later on how we can circumvent that. Yeah, but by and large, before you reduce your salary, first, always number one, if your employee is not covered under the Employment Act, look at your contract. Does your contract contain a clause for salary reduction? Now, I understand most of my clients, they wouldn't have that. So then you go on to the next question. Consider if salary deduction is the best step. Now, what other steps are there? So there are things like reduction of work hours. You can reduce your work hours. You can reduce. You can change the job scope. So there are other options in which you can exercise as an employer to provide the best option, not only for your employee, but also the company as a whole. And in reducing your salary, like I've said earlier, you can consider the wage subsidy program. Yeah. One of the methods I see for some companies is that they pay a base and then a commission. Now, what you can do is you can offer to employee, look, John, I'm using John again. John, your salary is 4,000 ringgit. For example, your commission is 10%. Now, what I can do is if I can quantify the performance, the commission, yeah, as in their performance percentage can be quantified. For example, if you bring in a certain numbers of sales, okay, I will increase your commission, right? I would increase. So if that is quantifiable, what I would suggest for some of the employers out there is to reduce the basic salary and then increase the percentage of commission, right? That would be one of the ways that you can do. But again, it comes back to consent. Always remember, consent is the key word here. Sit down, discuss with employees, talk about, explain to them why you are doing this. Very important, very important. Okay. I've said that if a salary reduction is unavoidable, apply salary reduction across the board. Try your best not to pick and choose which employee not to. Okay, for example, you have a pool of 100 employees, right? You have a pool of 100 employees. Now, 70 of them accepts the 100 employees, you only apply deduction for only a very small percentage, let's say probably 20%. And the others, the other 80% of your workforce, you did not do a salary reduction. The court might look at this as unfair. Now, to be safe, and I always advise some of my clients, do the salary reduction across the board, right? So that this would be considered fair. So, for example, 100 employees, you propose a salary reduction, and 80 of those employees accept the salary reduction, and 20%. Now, some lawyers may disagree with me on this, but I'm going to take the bold move to say you can, for the remaining balance, you might be able to impose the salary deduction unilaterally. Of course, the law is very fragile on this. Some employers might disagree with me, but always remember, when it comes to implementing a policy, the policy needs to be fair for everybody, right? For everyone. Yeah. Okay. Second option. The second option is a temporary layoff. I'm not going to touch too much on this because it's basically pretty straightforward. Yeah. A temporary layoff is basically a suspension of work for a temporary period. You can do it for 2 months, 3 months. Yes, but keep in mind that these temporary layoffs might be considered fair if and only a fair wage package is given, or severance or a compensation period for the period. So you're telling the employer, okay, John, I'm laying you off, right? I'm laying you off, and for that 3 months, okay, I'm going to give you maybe 2 months of salary or 1 month of salary. So see if the employee is amenable to that. Yeah, and in that temporary layoff, and you can even consider assisting these employees possibly to find a job somewhere else. Yeah, but again, I cannot stress this. Again, consent must be obtained, right? And keep in mind that all temporary layoffs, including retrenchment, which I will discuss later, must be reported to the Labour Department. So if you're going to do an exercise, please give notice to the Labour Department that you're doing this. Otherwise, it might be considered unfair. Yeah. Okay. Now I'm going to voluntary separation scheme. Okay. What is a voluntary separation scheme? Now, we are hearing in the market there are a lot of options. There are a lot of things like VSS, MSS. A lot of these things are in the market, right? But what are they? And voluntary separation scheme is basically in very, very simple layman words, employers will offer to these employees, okay, I'm going to give everyone a severance package, right? I'm going to give a severance package of 1 month, for example. And that 1 month is then written in a circular, okay, like an email or a memo to everyone. Okay, everybody, we are going to offer. The keyword is offer. You're not imposing a severance package. It's very different. That's why the keyword is voluntary separation scheme. We're telling everybody, okay, I'm going to give 1 month of 1 month as severance pay, and including your annual balance annual leave. Who wants to apply, right? This is a very, very good way of reducing your workforce, right? Okay, for example, you want to do a VSS, you want to conduct a VSS, okay? You conduct a VSS, 100 of your employees, you conduct a VSS. Let's say 80% of your workforce applied for it, and just a remaining balance. Now, if that remaining balance rejects the VSS, okay, fine, then you can then retrench them, because the court would look at whether or not this is a bona fide or genuine exercise of retrenchment. And voluntary separation scheme is definitely one of the great options that an employee can take before considering retrenchment. And what makes VSS so great is that it's voluntary. I apply for it. Yeah, and this works very well with especially big companies. Small companies, I would recommend smaller companies. I would recommend a mutual separation scheme, which I will discuss later. Now, what this option? What would a typical VSS contain? What are the characteristics? Right? What are the elements? Number one, like I've said, offer letter. Number two, you have to explain in your letter why you're doing this. Okay, for example, in this situation, in this COVID-19 situation that we're all in, we're going to explain as to why the employees would explain, okay, in view of this pandemic, we are restructuring the company and we're considering, we're taking measures to cut costs. Okay, provide a justification and then attach to that offer letter an application form. So this application form represents their voluntariness, as in you can apply for it, right? So that would be good for the VSS, okay? And then you would then in that application form give a deadline. Now, I've always advised my clients or some of these employees, give a very short don't give such a long deadline. You give 3 months. The employee is going to think. The employee is going to take their time to think, and then this totally decreases overall productivity. So my suggested deadline is probably 1 to 2 weeks, or maybe 1 week. Yeah, and also give, of course, state out the benefits which are being offered. Okay, now VSS, what you need to do in order for a VSS to be successful. Number one, never ever again pressure your employees to apply. So if your VSS says you better take this VSS, okay, you better take this VSS or I'm going to fire you. Okay, that is pressuring. But if it all really depends on how you explain it to them, right? I would always recommend face-to-face. And now, of course, we can't do face-to-face. My suggestion would be probably do it over a Zoom meeting or hangout, and you sit down, you explain to them, look, company is now doing a VSS. Okay, company now is doing the VSS, and what we can offer as a VSS is this, right? And if you're not going to take this, I have no choice. But the retrenchment benefits may be lesser, right? And that in that way, it wouldn't be construed so much as force. So always remember, coercion is always, you deal in absolutes. It's either A or B, right? So it's very important how you engage your employees. You must keep an open mind, right? Okay, and I've covered that. Deadline should be short, yes. Avoid lengthy periods. And yes, and if they find that they're cornered to a position where they can, especially when they record these conversations, yeah, I've done cases where employees actually record, or employers actually record the conversations without the consent, and that in itself that can be admissible in court, yeah, in industrial court at least. And these are evidences, or these are evidence that can show that the employee has resigned, not voluntarily. They are forced to resign, yeah, because of a certain package that they're supposed to take. Yes. Okay. The other thing I like to recommend for some of you employees out there is to number one, of course, ensure that the VSS is clearly drafted. So the elements that I spoke about, a clear definition of why, a clear justification of why you're doing this VSS, a clear justification of how much you're offering, an application form. All these are very important. Okay. Secondly, the VSS must be attractive to employees. If you're gonna offer them a VSS, don't offer them 2 days salary. Don't offer them 3 days salary. Look, as a guy, I would always advise employers look at the termination, look at the clause, look at the employment contract, look at the termination clause. If the termination clause provides for 1 month, then you can start with 1 month, right? So that'd be great. But VSS, the difference between this and a mutual separation scheme is that VSS is something which you give out to everyone. You send it out to all your employees and say, this is my package. You want to apply? Okay, come to me. Right? This is very different from a separation package. This is a very different separation package where negotiations and meetings will be held more in order to actually ascertain what is the best option for the employees, right? Okay, now I'm going to mutual separation scheme. When you do a mutual separation scheme, this is one of the considerations that you can take. Let's say you have 30 employees, right? 30 employees, you want to conduct a mutual separation scheme. Now, the mutual separation scheme will be done in one-to-one, always one-to-one, right? Or if it's inevitable, perhaps the boss and probably the HR director will be there, right? You sit down, and employees must keep an open mind, right? They must always have the idea that the first offer that I give will not be the offer that the employee will take at first when they meet for the first time. Yeah. And what you can do is you sit down and you discuss. Don't prepare the mutual separation agreement first. Sit down, discuss, have an open-minded meeting, right? As to what is the best. And most importantly, and if you're doing employee mutual separation scheme, my suggestion is to record it, right? Record the conversation, because this would show that the separation scheme is not accepted under duress or coercion, right? Because if the mutual separation scheme is in any way accepted under coercion, it can be challenged. So, for example, if John is being asked, and John every time, so John is being asked for a mutual separation scheme, the employee proposed to him, he says, "Okay, I accept it," and then he goes to court and he claims for unfair dismissal. Possible. It's possible. It's very possible. So employees are advised to tread very carefully. Okay. I've already said discussion should be minuted. Okay. Yes. The other thing I need to emphasize for mutual separation scheme is that you must also give your employees sufficient time. So don't propose like, okay, I want to do a mutual separation scheme. Sit down, tell them, okay, today I'm going to propose 1 month salary for a severance, and then you say, okay, you have until 5 p.m. today lah to accept. This puts a lot of pressure to your employees. So possibly give them maybe a week or a few days to think about it, because if you're going to tell them, look, this is the situation, we're just going to give you 1 month. If you don't like it, then we just terminate you. You know what I mean? It's going to go against the whole idea of a mutual separation scheme. The whole idea is to have a negotiation and a voluntariness, an open-mindedness to this whole scheme, and this is one of the very good ways to reduce your workforce. Yeah. Okay. Okay. Then the other thing I just want to emphasize is the idea of retrenchment. Okay. Now, retrenchment should always be a last resort. And why do I say that? Because retrenchment is basically telling, okay, 80% of your workforce, I've done a VSS, I've done a voluntary separation scheme, and now I want to retrench these 20 employees. right? These 20 employees will have to these 20 employees will be then retrenched unilaterally. So basically, you're telling the 20 employees, look, this is the severance package. Take it and go. So basically, that's what you're telling. But to do that, there are a number of requirements, right? Before considering retrenchment. So retrenchment, again, I emphasize, should be always the last resort. Yeah. Okay, I'm told that I need to wrap up in the next 5 minutes. Okay, I'm sorry. Okay, let me just move on. Okay, a very important requirement is the two things. There are three things. There must be a surplus of labor. Number one. Number two, foreigners always out first. Always, foreigners always out first, right? PR is not considered foreigners. Last in, first out principle. Last in, first out principle is a situation where the most junior employees must be out first. So when you're considering a retrenchment, please look at your workforce as a whole. Please look at what are the options you can take. Look, you say, okay, probably this department has 10, 20 junior employees, 10. So you would have to look at the 20 junior first before looking at the 10. But there are situations where you can depart from the LIFO principle. And at LIFO principle, and for example, there is a case.
Sorry guys, we are experiencing a little technical difficulties. Please do stay on with us, and also if you have more questions, you can post it on the Facebook, and we will try our best to answer. Okay. Okay, we are trying our best to work with him at the backstage. So just kindly bear with us for just 1 minute. Okay. Well, while we are waiting for him, allow me to do a little commercial break for Enterprise Asia. We are actually having quite a bit of upcoming events such as summits and awards after the MCO at the second half of the year. So actually, if you want to know more about our events, you can come on to Enterprise, follow us on Enterprise Asia Facebook, and also visit us on our website, www.enterpriseasia.org. Okay, they are still working with him.
Okay, sorry, everybody. My battery got. Okay, anyway, how many more minutes I have, Elizabeth?
Okay, we still have 15 minutes more. So
Okay.
how about we jump straight to the Q&A?
Sure. Actually, yes. Let's jump to the Q&A. Yeah.
So actually, okay, let's start Q&A. Okay, we have one from Nicholas Chin. What is the process for laying off a staff? Can this be done after the MCO, or can notice be served during the period?
No, you can. Laying off a staff doesn't have to be after the MCO period. You can even do it now. And what I would suggest is, what you can do now is do analysis of your company. Look at the structure of the company. Is this, for example, is this department in a surplus? Is this particular job? If I need 10 people, if I need only 3 people to do a 10% job, 10% job, then that's considered surplus. So look at these factors before you then exercise a laying off or retrenchment. Yeah.
All All right. Okay, next we have interesting one from SK Surain. What if an employee does not want to go to work because they are anxious about COVID-19 even after the MCO is lifted?
What if an employee does not want to go to work because they are anxious about COVID-19 after it's lifted? Yeah, that you would then have to discuss with your employer. You have to speak to your employer. Look, I'm anxious. I'm not. I don't really understand the context. Anxious. I think meaning that fear of getting COVID-19. I think that's what you mean by anxious. I'm just going to assume it's that. And if you feel that you're anxious in that manner, then you will have to discuss with your employer. You have to discuss with your employer, because if you don't come to work without any reason, you are going to be considered absent from work, and absenteeism is a misconduct, right? Which then entitles your employer to terminate you based on grounds of misconduct. So bottom line is, don't do that without speaking to your employer first. Okay? Right.
Okay, let's move on to Stephen Leong. Stephen Long. One of the conditions of the pre-Hatin wage subsidy is to retain your employees for at least 6 months. So what if the business becomes unsustainable during this period and has to retrench employees to stay afloat?
Exactly. So if the Peso package says there's one condition that they have to retain employees. If it becomes sustainable, then you would have to, what you have to do is, if it's within the first 3 months, then you have to conduct a retrenchment exercise. No issue. But what you have to do is you have to then inform the labor department and also the Peso department that you're retrenching those employees. So yes, that would answer your question.
All right. We have another one from Irene Koo. Does it mean if the employer demands for a salary cut, the employee can demand to reduce working hours to match with the pay cut?
Does it mean if the employer demands for a salary cut, the employee can demand to reduce the working hours to... Okay, when you say demand, I assume you mean you take the thing or leave it, right? If you're an employee and you're faced with that, okay, record the conversation, take it, claim constructive dismissal if you're an employee. Now, of course, if you're going to say the employee can cut and demand, yes, they can. Of course, they can, because that would be outside the ambit of contract. Because if your contract does not have any clause to say that you are your salary can be deducted, then you have the leverage there. Always remember, when it comes to a reduction of salary, always remember that as an employee, if the contract does not contain a reduction of salary clause, then you're on a high footing first, right? And then you would then say, instead of reducing my pay cut, I want to reduce my working hours. Which is fair. It can be fair. But again, like I mentioned just now, that if everybody accepts the salary pay cut 80% and you're that 20%, and they retrench you, the court might consider that fair. So please keep in mind also what happens to the other workers also might affect you. So yeah.
Okay, we have an interesting one from Y Ping Chiang. Okay, if we go for salary deferment to pay 80% now and balance to be paid later, like 3 months, do we need to lodge with JTK?
Sorry, if the salary
deferment.
If we go for salary deferment to pay now and balance to be paid after 3, if you are a salary deferment to pay 80% now and balance. Okay, if you want to do anything to do with salary adjustment, salary deferment, these things has to be lodged to JTK only if you are less than 2,000. Anything above that, that depends on both you and the employee. So there's no requirement for you to report if you do a salary reduction if you're above 2,000. Yeah, only in situations for VSS, situations of temporary layoffs and retrenchment. These are few of the options that when an employer takes, they must inform the labor department.
Okay. From Neil James, can the company deduct my annual leave for working from home?
First of all, again, I'm not sure whether you are below 2000 or above 2000, but I'm going to assume you are above 2000, and if so, they generally can't do it without your consent. Again, this must be impressed upon, that you can only do an employer cannot simply utilize your annual leave without your consent, because annual leave is basically the logic behind it is that you apply for an annual leave and then the employer accepts it. The employer cannot say, no, you take leave, and then they force you to take it, and then it's not feasible at all. It'll be considered unfair. Yeah.
Okay. Actually, there's one from Darshini.
Narshini.
Yeah, Darshini. She's saying like so many businesses are actually going bankrupt, right? So
Yeah.
they cannot pay. How do they carry on with no money? And she continues by asking like the bigger issue is companies who can pay but choose to sack employees because they are opportunistic.
Can you repeat that question again? Can you just repeat that question? It's pretty long.
There are companies who can pay but choose to sack employees because they are opportunistic.
Okay, right. Okay, I answer that first. If the company can choose to pay, but they don't pay, in a sense, when I mean don't pay, meaning that they just retrench you, and let's say they just give like 10 days. These people, that means they have not been done. They are not doing the retrenchment exercise in a genuine way, right? One of the requirements of retrenchment, I did not cover that. I've covered it just now. Is that you must justify to court that your finances are declining. If you cannot justify that factor, it likely be that the retrenchment exercise is not going to be there. And as an employee, what you can do is, one of the suggestions is to do a CTOS search, right? You CTOS search or an SSM search, you check their company's accounts. If they are in good financial health, there's absolutely no reason why they can't retrench, you see. But having said that, if indeed that the company has really almost like closing in on zero, right? These companies can actually jump straight to retrenchment instead of doing a VSS, because they have no money for that. They have no money for MSS, VSS, whatever, not layoffs and everything. They don't have money for that. We'll go straight to retrenchment. So it really depends on, number one, if the company's finances are declining, you must ascertain that. And not just I'm projecting it to decline. It has to show that the finances are declining. And secondly, evidence. You can say a lot of things, but when you bring to court, you're saying you're not coming up with your financial statements or audited statements. It's going to be very hard for you to prove that you are indeed of negative financial health. Yeah.
Okay. Okay, one from TJ Valerio. If we decide to cease business, can we terminate staff without compensation?
If we decide to cease business, can we terminate staff without compensation? First of all, you have to look at the contract, right? And my suggestion is to not do that. Because usually contracts will contain a termination clause, which is that I can terminate you based on 1 month of salary, and you likely have to pay that 1 month of salary or 2 months of salary. So yes, and my suggestion is, when you trench employees or you want to terminate this staff because of your finances, always remember that these must be done through the principles of LIFO and foreigners in, foreigners out, that kind of principle, and the thing has been redundant. All this must be thought out first before taking a step to terminate an employee. But I wouldn't suggest terminating a staff absolutely without compensation. Like even if you got 10 days, you should bare minimum give as best as you can. Yeah, because you do not want to. The less compensation you give, as in the less compensation you give, it is likely that the court may look at this as unfair, given your circumstances. Yeah. Okay. Next question.
Right. Okay. There's Okay, one question here. My employee is missing from work since the start of MCO. What
Yeah.
legal actions can I take?
I like these questions because I actually get a lot of these questions. Absent from work, working from. Okay, number one, what you can do. First of all, get the WhatsApp the employee, email the employee, send the employee. To ascertain how many days that he has been absent. Now, I'm not sure what Elizabeth your work, what does your employee do? Because if your employee says, I cannot work from home, what? I can't work from home. So I'm missing from work, and that's why. So that they may have an argument there. But if they can work from home, then send them a letter, say that please reply within 14 days as to why you have been absent from work from date 1st April to 20th April. Send them. If they don't come back, okay, it's actually a show cause letter. This is entitled show cause letter. If they don't come back, then they can then reply. Then you can proceed to do perhaps a domestic inquiry, right? A domestic inquiry like Zoom or via Zoom. And then once all that, because it's considered misconduct, absenteeism conduct, misconduct, and then go through the process of the domestic inquiry. If they don't, even if they don't attend, if you have given them warnings, then you can terminate them. Yes, it's either you give after issuance of show cause. It's either you give warnings, right, or you can proceed to domestic inquiry and then proceed to terminate them. Yeah, but you cannot just terminate them immediately. Like that is my opinion is that summary dismissals are only summary dismissal are only reserved for things like theft or stealing company funds or even fighting with a senior employee. So those are it causes harm to other employees. So that can justify summary dismissal. But for absenteeism, I would say to be on the safe side, please give a show cause letter, conduct domestic inquiry, and then terminate.
Okay. Okay. There's one here. How can employer consider to revoke offer?
How can employer consider to revoke what offer? What offer? I'm thinking offer of VSS. Offer of you can if it's VSS or MSS, if that's what you're talking about, then yes, you can. And after, let's say if you give a VSS, you can, before the conclusion of the VSS, you can revoke it. Yes, possible. And if you do that, please send it to an email or a Zoom or a WhatsApp conversation to our employees. Yeah, I'm not sure, Justin. I'm so sorry I can't answer you, but if you can provide a bit more context to your question, I'm able to answer it. Yeah.
All right. Okay. Next, we have one from Noreen. Can a company terminate or lay off me during the MCO without any separation package?
I would suggest no. For employers, no. My answer is still the same from just now. My suggestion is to not do that because employer contract will contain a termination clause which an employee will have to give compensate you with the salary. Or not compensate, they give you a salary unless of course they ask you to still work. And then possibly yes, but I generally no. Yeah, generally no. For all questions, generally no. My answer to termination without compensation is generally no. Yeah.
Okay. Okay. I think we only actually time is kind of running up. How about we take one last question? Actually, there's one interesting from Noreen also. Can a company lay off an employee whom is senior, however keeping the new and removing the older staff, meaning like first in, first out?
Can the company lay off an employee whom is senior, keeping a new staff, keeping a new and removing the older staff? Let me first in first. Meaning that I'm assuming that you remove a senior and keep the junior. I'm assuming you're saying that yes, you can. Okay, you can do that, but okay, there is a case of one of these university case. I forget the name, but I can provide to you the case. But what had happened was the lecturer, they actually retrenched the senior lecturer on and keep the junior lecturer because on the basis that the junior lecturer uh, could teach the students more subjects if they could. In other words, their job function is much wider than a senior. In those situations, yes, it's much more feasible for you to keep these junior employees as opposed to skill. Of course, it's subject to other requirements, but generally, yes, you can depart from the LIFO principle.
Okay. All right. Thank you so much. And basically, I'd like to address it to the audience. If you have any questions we didn't get to today, or you have new questions at all, please contact Yu Szen at the email shown on the screen.
Yeah.
All right, if you have any more questions and inquiries. So this video will still be available on the Enterprise Asia Facebook page. To mention again, if you want to know more about Enterprise Asia, please do visit our website at www.enterpriseasia.org. And thank you, Yu Szen, for this very informative and insightful presentation. And on behalf of Enterprise Asia and Help University, thank you everyone for attending today's Room to Infinity live talk on legal options and responsibilities for employers. We hope to see you again next time in our Room to Infinity series. All right, thanks guys, bye.
Okay.